Good morning, everyone, and welcome to Landmark Chambers Planning High Court Challenges 2024 webinar series. This is the first session of the series, and it deals with environmental law issues. We're delighted to see so many of you joining this morning, and hope you will find the presentations interesting and informative. My name is Goodman KC, and I will be chairing the session, joined by my colleagues Goodman KC, Dr. Ashley Bowes, Matthew Fraser, Nick Grant, and Alex Shattock. So let's begin. First of all, I'll just introduce everyone, as I said. Goodman KC practices in all areas of planning, public and environmental law. He frequently appears in the higher courts and recently led the successful appeal about open space in the Supreme Court in Day against Shropshire. He was awarded Legal Aid Lawyer of the Year Outstanding Achievement Award in 2021. He was appointed to the EHRC's A panel in 2019, and he'll be speaking about two cases in which he acted this year for the NGO Rights Community Action. So we look forward to that. Dr. Ashley, specialises in all aspects of development and use of land. He regularly acts for developers, government departments and private individuals in inquiries, local plan examinations and litigation in the courts, again, all levels, including the Supreme Court and Court of Appeal. He is consistently ranked as a leading specialist in the directories, and this year was described as a planning maestro. So well done, Ashley. Alex Shattock does a lot of environmental law work and was instructed for the claimant in the Cumbria coal mine case, the Net Zero Teesside DCO challenge, and the Rights Community Action energy efficiency cases, which I just mentioned, that Alex Goodman's involved in, and challenges to various road development consent orders, which I was involved in as well, but on the other side. Matthew practices widely across planning and environmental law. Of particularly relevance to today, he acted in the planning inquiry and subsequent High Court challenge in the MS challenges in their application to demolish their Marble Arch Oxford Street store and construct a new retail and office building. He represented the main objector in that case, Save Britain's Heritage, and you'll be hearing a lot more about that in a few moments. Last but not least, Nick is, again, a planning and environmental law specialist. He's ranked in both directories and Planning Resource magazine. He's also appeared again in all levels, from inquiries to the Supreme Court, and he's also represented the UK before the UN's Our House Convention Compliance Committee. Key recent cases include Finch in the Supreme Court on EIA, Fry, which we'll be speaking about in a few moments, Coldwell on enforcement notices, and the Whitehaven coal mine litigation. He's also acted in numerous large inquiries, including big housing inquiries, one in Dorset, and Solar Farm DCO, and the Lower Thames Crossing DCO. So there are your speakers for today, and I'll now hand over to the first one, which is Nick, for his presentation on Habitat's Review of the Year. Over to you, Nick.
Thanks, Jenny, and good morning, everyone. There are three cases I want to that I'm going to speak to you about today. The first is Bradbury, the second is Fry, and the third is Ward, which deals with water neutrality rather than nutrient neutrality. Because I'm focusing mainly on legal challenges in the planning specifically context, I'm not going to go over the River Action UK case, but worth being aware of for those practicing in wider environmental law. You'll be familiar with the Harris judgment of 2 years ago now, I think it is, which effectively upped the requirements on the Environment Agency in Harris, that is to comply with our regs 9, 2 and 3 of the Habitats regulations, where the Environment Agency was the sole authority required for checking compliance with those regulations in its particular field. The River Action UK case, which is, I've put the reference up on your screen, deals with the situation where the agency was not the sole agency. So it's a helpful follow on from the Harris judgment. But because it wasn't planning, I'm not going to say anything more about it. So I pick up with Bradbury, which is a case about planning permission in the Snowdonia National Park. Planning permission has been sought and granted for a large livestock shed and sheep handling system, not Snowdonia, Brecon Beacons National Park, sorry. Now that was within the catchment of the River Wye Special Area of Conservation, and that had been suffering phosphate pollution from manure. Planning permissions had previously been granted but quashed, and in each of those previous grants, the Habitats Regulations Assessment concluded that there were going to be adverse impacts on the site integrity or that it couldn't be ruled out of the River Wye SAC. Now, after the quashing, Natural Resources Wales issued new guidance ruling out adverse effects for some developments, and so the Habitats Regulation Assessment for this planning permission was going to conclude that there would be no adverse effect on site integrity based on Natural Resources Wales guidance and conditions. But crucially, by the time that planning committee members were due to make their decision, they hadn't been provided with that assessment and it hadn't been put online. Now, they'd been told that it had been sent to Natural Resources Wales for review and sign off. It would have been obvious to them that the sign off was going to be fine, no adverse effect on site integrity, but they weren't given the document. And that, sorry, just because something's gone wrong. There we go. That's what gave rise to the grounds in this case. So focusing on ground 2.1 was that the defendant had breached the Local Government Act in failing to publish the updated HRI screening matrix and appropriate assessments. As I'm sure many of you will be aware, the Local Government Act basically says you have to publish the background papers and the reports relied on, and this was saying we breached that. And it was also procedurally unfair because for members of the public, they hadn't had an opportunity to comment, and then for members of the committee, they had been deprived of material evidence. So what does Regulation 63 state? Because that becomes important for understanding how the judgment came down. I've put an extract on your screen, but basically a competent authority, before deciding to undertake or give any consent, permission or other authorization for a plan or project likely to have an effect on a European site, has to make an appropriate assessment. It must also, subsection 4, if it considers appropriate, take the opinion of the general public, and if it does so, it must take such steps for that purpose as it considers appropriate. And then in the light of its conclusions on the assessment, and subject to Regulation 64, Reg 64 deals with what we call IROPI, which is, yes, there's going to be harm, but there's overwhelming reasons of public interest. So subject to that, then the competent authority can only agree plan or project if ascertaining that it will not adversely affect site integrity. So it was stage was set for an interesting judgment. Key points that come out of it, I'm not going to go through the judgment paragraph by paragraph. First, the judge set out a pretty helpful summary of what Regulation 63 requires, and effectively it requires the competent authority to make a decision based on the conclusions of the appropriate assessment. But this is a separate decision from the conclusions of the appropriate assessment itself. Now, that separate decision is usually made by the person deciding whether to grant planning permission. Usually the committee might be delegated, and again, it can't be granted unless there's no AEOSI. Now, effectively, what was the defendant in that case was basically saying was, look, yes, they weren't given this paper, but a committee, a decision maker basically rubber stamps the appropriate assessment. They're not going to undertake a separate evaluative finding. So we all knew what the appropriate assessment was going to say, therefore no breach, don't worry about it. The court said, no, actually, it's not. The separate decision taken by the committee is not rubber stamping the appropriate assessment. And it is possible, and the High Court said this obiter discursively, but I think certainly something to be aware of, the committee could lawfully disagree with the conclusions of the appropriate assessment or factual premises within it. So, for example, if you've got concerns about water flow and the appropriate assessment put forward by the developer says one thing, and you get reams and reams of public consultation saying, no, here's our scientific evidence that says something else, the committee can lawfully say, no, the appropriate assessment's got it wrong. Even if it was, for example, even if it was put together by in-house, like a shadow HRA, for example, that you sometimes see. So there is a separate decision-making function for the committee, and therefore ground 2, subpart 2 was well-founded. That was an unlawful decision. It followed from that ground 2.1, which is the breach of the Local Government Act, was also well-founded because either the appropriate assessment was being relied on, in which case it needed to be summarised and provided and treated as a background paper under Section 100D, or it needed to be ignored altogether. And if it was being relied on, needed to be out there, and if it was being ignored, they had no material on which to say no adverse effect. So, key point coming from this case is that if you're a planning committee, you need to actually have available to you the habitats regulation assessment, the appropriate assessment, and it needs to have been put online. Now, on the facts of this case, the decision wasn't quashed because the court said, well, look, based on where it was going, based on what everyone knew at the time, it's inconceivable there would have been any material difference. So the outcome was the same, but the legal point was not. So that's Bradbury. CG Fry is a major Court of Appeal case that happened, I think, in June, July, which deals with effectively whether you have to undertake a habitats regulation assessment when discharging conditions. So the facts of the matter are these. Jurston Farm was a major outline consent granted in Somerset in 2015. It was brought forward in phases. Phases 1 and 2, I think, were done. Dr. Ashley will correct me if I'm wrong, as he acted for the claimant in the case. And phase 3 was granted reserved matters consent in 2020, subject to certain conditions. Now, some of these were pre-commencement conditions, some of them were not. In July 2021, Natural England set out in its advice note on the Somerset Levels and Moors Ramsar site, and that basically said the SAC SPA element of it is fine, but the Somerset Levels and Moors Ramsar site specifically, they had concerns about nutrient loading and the damage that was doing to the various special interests within it. And so Natural England said effectively one thing you might want to consider or need to do is basically have the dreaded nutrient neutrality condition. So you have to show that the development would be neutral in terms of the phosphate and nitrate loading on the Ramsar site. The appellant then sought to discharge its conditions on phase 3 in September 2021, but the LPA, which was Somerset, refused to do so. There was no appropriate assessment because there'd been no concerns when it had got its permission or its either outline permission or reserved matters, and the appellant didn't put in an appropriate assessment at condition discharge stage. There had been a shadow appropriate assessment produced by Somerset itself showing that the AAOSI couldn't be ruled out in the absence of mitigation. So it refused to discharge. That got appealed to the Secretary of State. The Secretary of State also refused to discharge the condition applications. It went off to the High Court back last year, and the High Court refused the grounds of challenge, and that sets the stage for challenge to the Court of Appeal. So what's the legal framework? Well, I've run through Reg 65 just now, but Article 6.3 of the Habitats Directive requires an appropriate assessment before a competent authority agrees to plan or project. That's the key term in the directive. Now, agree is a term of art, but the CJU have said interpret it in line with what is meant by, in the EIA context, granting development consent. And that basically in that context, that separate EIA context, agree means the decision which entitles the developer to proceed with the project, sometimes known as the implementing consent. Domestically, this was transposed into the Habitats Regulations 2017. So Reg 62, Reg 63, as I say, I've outlined, that's the general, you must not grant consent unless sure there's going to be no adverse effect. Regulation 62 says that the assessment provision is Reg 63, apply subject to and in accordance with chapters 2 to 7. Chapter 2 is planning, and we've got Reg 70 here. Now that includes specific provisions for the grant of planning permission. It specifically requires the Regulation 63 appropriate assessment process to be gone through before granting outline permission, Reg 73. It doesn't say that AA can only take place at outline stage, but it doesn't also say in terms that appropriate assessment can take place later. So that's the legal provisions that the court needed to grapple with by way of other sort of background jurisprudence. Not in dispute, the habitats regulations are intended to provide a strict precautionary approach. That comes out of CJU case law and, of course, domestic case law. We had 2 High Court decisions, not quite on this point, but on similar. That was Wingfield and Swire, and those dealt with undertaking an appropriate assessment at reserved matters stage, so not condition discharge here, but the stage before that. And Ramsar sites, and I emphasise the Ramsar site because, of course, the habitats regulations only protect special areas of conservation or special protection areas. That protection is extended to Ramsar sites through the National Planning Policy Framework. It's the NPPF 181 that says Ramsar sites should be given the same level of protection in planning decision making as special areas of conservation and special protection areas. So what were the grounds? Well, the ground one is that regulation 63 of the HABS regs doesn't apply at condition discharge stage at all. Ground three is that if it does, well, the scope of assessment is limited to matters affected by the condition to discharge. So for example, if you're discharging a trees condition, that's going to have absolutely no impact on SAC nutrients. So you don't need to think about this for trees. Don't worry about it. So that's grounds 1 and 3. And ground 2 was slightly different, but says even if it all does apply, it is legally irrelevant. The impact of discharging the condition, the fact that the development is going to come forward, is legally irrelevant, because what's left open for condition discharge stage is within the four corners of the condition. So again, if it's trees, you're only concerned with trees. You're not concerned with the discharge, with the consequences of discharging. And it was then said that MPPF Para 181 is seeking to make legally relevant something which is legally irrelevant. And that argument was made by reference to relevant Supreme Court cases like the LSIC case from 2017. So we get to the judgment. A couple of really interesting points come out of this. Now, the first talks about the approach to interpretation generally, because below in the High Court, Cranston had said that on a strict reading for habitats regulations, and I'm paraphrasing, they don't make provision for discharge at condition stage. And so part of the argument put by the appellant was, well, that is right, that's what the words say, and therefore the question is, does the context change that? And the Court of Appeal basically rejected that two-stage approach. They said whenever you're interpreting legislation, it's one unified process. You don't start with a linguistic exercise isolated from context and purpose and then move on to context and purpose. It's all one uniform exercise. And fundamentally, this is because a legal norm is intended to have some effect in the real world. Therefore, you look at it in light of the purpose it's designed to achieve. You don't separate the two. And it gave us some Supreme Court cases on that point. So that's general approach to interpretation. On ground one, the Court of Appeal said that the inspector and the High Court were right. Reg 63 and 70 don't exclude the requirement for appropriate assessment at reserve matters or condition discharge stage if the authorization is necessary to enable the project to be lawfully implemented. Regulation 63 is drafted very broadly. It captures a wide range of authorizations. Remember, it's any consent, discharge, or other authorization, and its purpose is to avoid any risk of harm to the integrity of the site. That's the strict precautionary approach. That purpose, the precautionary principles show it extends beyond the initial stage in the decision-making process. The concern here effectively was a lacuna. We now knew at the time of the decision that discharging could cause harm. So even if it had been missed at the earlier stages, the precautionary approach is, well, then you need to do it at this later condition discharge stage. So Reg 63 allows an appropriate assessment to be undertaken when the authority is making the final decision in a sequence authorizing the development to proceed. And that can include deciding whether to discharge pre-commencement conditions whose effect is that development carried out in breach would not be authorized by the planning permission, i.e. the Wigley type pre-commencement conditions, where, again, I'm sure many of you will recall, if you try and implement a consent in breach of certain pre-commencement conditions, it's not been implemented, you don't get the benefit of it being implemented. Go back to go and it could very well expire. So those conditions this can apply to. So that's what Reg 63 does, and the court said, and you read Reg 70 in light of Reg 63. It doesn't state or imply the assessment provisions don't apply to specific types of consent, permission, or authorization. It's basically, it doesn't cut it down. That's what Reg 70 does not do. That's what the appellant was arguing it does, and the court said no, it doesn't. Ideally, you'd undertake appropriate assessment at the first opportunity, but that does not mean that if it's missed for whatever reason, then you don't need to do it when making a subsequent implementing decision. That would be incompatible with the purpose of the habitats regulations. Now, one of the arguments that had been put by the appellant was this is taking away our private rights, and you can't do that. Planning permission confers valuable right. We've got this right. We can bank it. You can't take it away, and that is the effect of what you're doing. And again, the Court of Appeal rejected that. And the reason I emphasize this is because I've got other clients where local authorities are taking the same point, and you can't move forward. It's not you have to go backwards. So the rights persist. You're implementing your planning permission and reserve matters persist. You just don't get to move past the next stage. Another argument was put was, well, we've got statutory provisions for revocation and compensation. So that's the route. Basically, a local authority or an authority has to grant permission, but then if it decides there's a problem, it has to take it away and pay compensation. The Court of Appeal said, no, that's not a proper alternative to HABs regs observance. Another particularly interesting point that came out of this decision was about the interaction between EU law and domestic law, because the court below in the High Court, Cranston had effectively, in part, relied on the idea of direct effect of the Habitats Directive, and the Court of Appeal here said, well, hang on a moment, we're reaching our decision on the basis purely of a domestic understanding, purposive interpretation of this law. You look at the purpose of the law, and that's how we're applying it. So it didn't rely on direct effect of the Habitats Directive and regulations, nor did it find that there was a conflict between understanding the HABs regs as you would under the domestic canon of construction or looking at it as the EU would interpret it. In this case, because of the timings, it was pre-Rule Act. Had there been a conflict, then due to the principle of supremacy, the EU approach would have won out. But obviously, that's not the case anymore post Rule Act. But in any event, the key point is effectively this is about the interpretation of domestic legislation. This is governed by domestic authority. There's Section 6 of the Withdrawal Act, which tells you how to take into account EU authorities. That was all that mattered. We did not, court thought, need to get into direct effect. On ground 3, which is very much an adjunct to ground 1, the court dismissed the argument. Effectively, it's not found in the legislation. It would be inconsistent with the fundamental object of it, which is a comprehensive scheme for the protection of important habitats. It would depart from the precautionary approach. So if the appellant's not getting home on ground 1, it's certainly not getting home on ground 3. On ground 2, which is the making legally relevant what would be legally irrelevant, this too was dismissed. The court said that NPPF 181 was engaged because of a consequence of discharging the conditions and the object of the policy behind it in the NPPF. Now that NPPF establishes as a matter of planning policy that Ramsar sites have the same practical level of protection in planning decision making as habitat sites. So once the harmful effects were a likely effect of the development, and those effects depended on the decision whether to discharge the conditions, NPPF 181 became a material consideration. In short, the consequences were relevant to the materiality of the condition itself. This wasn't, for example, an LSIC type case where an SPG had been promulgated saying whatever development you're doing, you must contribute to highways, because that lacked any connection with the development in question. And those are unlawful, but this isn't the case here because the impact of the concern is directly relevant to the question and the conditions that are being discharged. So that was Fry. Key case, as I say, on conditional discharge. Now we leave the hotly contested issues of nutrient neutrality and come to Ward, which is the question of water neutrality. So nutrient neutrality is dealing with the issue where phosphates and nitrates from housing development are being pushed onto these sensitive sites. Water neutrality, a particular problem down in Horsham in that sort of area, is where there is concern that the abstraction of water to domestic homes is going to have an adverse effect on those on SACs and SPAs that depend on the flow from water. So in this case, the claimant sought planning permission for mobile homes and a stable block in 2018 in the catchment of the Arun Valley SPA. The council refused it and the claimants appealed. The hearing in 2020 was adjourned due to COVID, and the claimants moved in December 2020. In 2021, Natural England published a position statement on water neutrality, effectively outlining the concern that I've just said, which is the abstraction from the feeders into the River Arun SAC is going to be too much. The reduced water is going to harm the protected characteristics of those sites. That was updated in March 2022, and there was a hearing in May that year. Now, the claimants argued that they had been occupying the site since before Natural England's position statement. So all they were doing was maintaining the status quo, and there was no need to show water neutrality. The council disputed this because they basically said, well, no, occupation's unlawful. This isn't part of the baseline because what you're doing is unlawful. You don't have permission for it. And Natural England, which was consulted and did respond, said that unless occupation had planning permission or was otherwise accounted for prior to, sorry, the date's gone grey on the bottom, prior in effect to position statement, then it needed to be water neutral. And so the question really turned on, was it otherwise accounted for? Now, the inspector said, no, it wasn't, effectively adopting the council submission, and the ground of appeal was the fact that the use was in fact taking place prior to the position statement meant it was otherwise accounted for. And again, in effect, the claim was dismissed. In light of Natural England's consultation response, it wasn't an error to treat otherwise accounted for as immune from planning control. Yeah, that was effectively, sorry. That was effectively the argument being put. Otherwise accounted for means otherwise immune from planning control. So if you've been there so long that limitation period passes, for example, i.e. it's part of the lawful baseline. That's the big question. Is it part of the lawful baseline? In this case, it wasn't. And it was not irrational or unlawful for the inspector to say, no, you don't get home on water neutrality. So that's all I have to say for my habitats roundup of the year. And I'll now hand over to Ashley.
Thanks very much, Nick. I'm going to talk about three things: environment impact assessment cases, the strategic environment assessment cases, and then a little look at what might be coming to change those regimes in light of the powers in the Levelling Up and Regeneration Act. So starting with EIA cases of 2024, well, the biggest case is obviously Finch. This is a case all about the retention and expansion of crude oil exploration. And the big question in the litigation was whether the assessment of the ultimate effects of refining and then burning and using the crude oil that was extracted from these wells was part of the environment assessment process, or was that something outside of that regime? The High Court said, well, as a matter of law, that's outside of the proper construction of the regulations. The Court of Appeal said, well, it might be, but it's a question of planning judgment, and on a split decision, the Court of Appeal thought the County Council had supplied adequate reasons for not assessing. And then it came to the Supreme Court. And the issue before that was encapsulated here, which is whether the greenhouse gas emissions which will occur when oil extracted from an oil well after being refined is burnt as fuel must be included in the EIA required before development consent may be given for the extraction of the oil. That was the question as refined by the court, and by a majority, the Supreme Court answered yes, as a matter of statutory construction, it was within it. It was a controversial decision in that there were two dissenting judges, but that's the majority decision and represents the current law. So it's important, though, to unlock this case to understand that there were two important matters of common ground, which might not apply in every case of this kind and may affect what the outcome would have been. The first one was that it was agreed that it was inevitable that the oil from the project, the crude oil that was extracted from this well for which planning permission was being sought to retain and expand, would be refined and would be eventually combusted. And the second point, and perhaps the most significant on the facts, is that it was agreed that the combustion emission effects could be estimated and established by using some form of methodology. And Lord Leggett said, well, the only issue was whether the combustion emissions are effects of the project at all. And then with those items of common ground, the court then went into examining how you might apply a threshold for determining the causation to see whether these effects are effects of the project. And it looked at various options. A but-for test, said to be the weakest test of causation. The strongest one is one which requires the occurrence of event X to be both necessary and sufficient condition for the occurrence of Y. And then an intermediate position, a proximity test. Potentially interesting for another case, but on the facts of this case, unnecessary, the court decided, because it's not necessary to consider what's meant by likely, because it was agreed in that case that if the project went ahead, the chain of events and resulting effects on climate are not merely likely but inevitable. That was a concession or a matter of common ground between the parties by the time it reached the Supreme Court, and so the court didn't need to look at whether there was the necessary causal connection. And agreed, it was also agreed that the extraction of the oil, not just the necessary condition of burning it as fuel, but also sufficient to bring about that result, because it was agreed that the extracting of the oil from the ground guarantees it will be refined and burnt as fuel. And of course, as we looked at earlier, it was agreed that those combustion emissions could be estimated, and therefore that could factor in some form of assessment in an environmental statement. The court didn't say which of those three tests or any test would be the right one to use in a future dispute where those matters weren't agreed, but you've got those three options for future litigation to draw on. Looking at the scope of EIA in relation to the transboundary effects question, the majority of the court held that the directive doesn't impose any geographical limit on the scope of environmental effects of a project, which must be identified, described and assessed when undertaking the EIA. There's no principle, so they held that if the environmental harm is exported, it could be ignored for the purposes of an assessment under the domestic legislation and regime. And of course, as is just a scientific fact, the impact of greenhouse gas emissions doesn't depend on the source of their release. They are effectively a global phenomenon once released into the atmosphere. And the scope of indirect effects can encompass those occurring away from the source. So some broader points of statutory construction which may be helpful for other EIA disputes not involving so-called stage 3, i.e. upstream or downstream effects. Here, the greenhouse gas emissions were, the court found, within the control of the site operators, because they could ultimately choose not to extract the oil in the first place, let alone refine and then allow it to be burned. National policy that was a matter of dispute in the case, it didn't restrict the requirement to assess the environmental impact, so the court found it wasn't an answer to say, well, downstream emissions are regulated by other regimes in the way that we might look at, for example, other effects like more broadly environmental health effects or effects on human health. It's sometimes said that those are controlled by other regimes and therefore able to be left outside or out of account of the planning system. Not so, said the Supreme Court, because there was a direct obligation in the EIA regulations to assess the effects of the project, and those effects comprise environmental information, and planning permission must not be granted unless the environmental information has been taken into account. To dismiss some of the concerns that were raised by the first instance judge, this wouldn't be a floodgates. Other raw materials such as steel and coal can be put to many different uses. The intermediacy of a future use may mean that a downstream effect from a particular future use could not be regarded as likely. Further, no meaningful estimate could be made of the emission. So that's, just as I said earlier, those concessions or common ground points in Finch meant that it wouldn't necessarily apply, or the same outcome wouldn't necessarily apply in a future case. There may be question marks about the causal link between the project and the emissions, and there may be a more practical concern, which I think is really where the Court of Appeal were coming from, which was about the ability to estimate or make some kind of meaningful assessment of those regulations, because of course the purpose of EIA is not a substantive one. It's not to decide the merits of the project. It is merely to present, to identify and assess the effects of the project for the decision taker and the public. In contrast, however, in this case, it was agreed that the oil from the project would be burnt and estimates would be possible. And it remains, though, an evaluative judgment for decision makers whether the effects are likely and it's capable of assessment, and the effects that were not capable of assessment are not required to be assessed. So that last bullet point there is, I suggest, really where future disputes are likely to be found. It's really going to be on the evaluative judgment of decision makers about causal connection and capacity to assess impacts. Bit of an update on the effects of Finch, though, that the government produced a consultation for offshore oil and gas extraction about stage 3 assessment, stage 3 emission assessments. That would not apply to a project like Finch, which was obviously an onshore extraction project, but useful and interesting, because the consultation is still live, so useful to bear that in mind, but also to give a bit of an indication where the government and therefore planning inspectors might be coming from in looking at the adequacy of environmental statements. Useful points to bear in mind. First of all, only apply to offshore, but no substitution, which is something that we'll look at in the next case, the West Cumbria coal mine case. And so I'll just park that and pick it up in a moment. But also the basis of the assessment should be the reasonable worst case. So i.e. the highest anticipated production level specified in the application. So if you're having a stab at stage 3, some downstream effects, you think there is a likely causal effect, or you're promoting a project where you think there's a risk that a decision maker might think there's a causal link. So you're doing the sensible thing and including an assessment in your environmental statement. Make sure you do it on the right basis, which is use reasonable worst case, because it's likely, although bear in mind this draft guidance wouldn't apply to an onshore project, but it's likely that a decision maker is going to come from the perspective that that would be the appropriate form of assessment. Turning then to the Friends of the Earth judgment, which was all about the West Cumbria coal mine consent. It concerned the correct approach to assessment of greenhouse gases post-Finch, and so is a very helpful recent illustration of the application of those principles. The Secretary of State had, however, conceded the case on the basis of Finch, and the developer was seeking to uphold it, not obviously to re-argue the legal conclusions in Finch. That would be an unpromising start in the High Court, but rather to suggest that on the basis of factual findings by the Inspector and Secretary of State, that the error in failing to assess stage 3 downstream effects was not material. The scale of the assessment was found by the judge, however, the scale of the emissions, should I say, was found by the judge to be an obvious material consideration. So they should have been assessed and weren't. But the interesting argument here was whether there would be a complete or perfect substitution. And what was being said was that the extraction of coal at the West Cumbria site would be offset by an equivalent amount of US coal remaining in the ground. And therefore, because of an equivalence, effectively, you wouldn't have an effect that needed to be assessed. But the court wasn't having that. It found the correct analysis was that if substitution would be a likely effect to the project, then that had to be assessed in addition to the output of the West Cumbria site. So if you are going to run that argument, and obviously one can see a logical basis for it, it doesn't excuse the description or identification or assessment of the effects of the project. It may, however, bear on the quantification of the significance of them if you're able to point to the fact there's going to be substitution, but it doesn't excuse you doing it in the first place. So that was the end of that. But in any event, on the facts, it wasn't really possible to argue because, as the judge identified, there was not, so the decision makers found a complete or perfect substitution anyway. So the point didn't run, so he found. But the more interesting point of general principle is that if you do find yourself making a substitution case, you've got to identify and describe the effects of the project in question before you then go on and ask yourself whether there's going to be a complete substitution or equivalence. Turning now to looking at the question of cumulative assessment. Substation action was all about 2 development consent orders have been made for offshore wind farms in East Anglia. They required an onshore generating station and associated grid connection and substation. That substation, it was agreed, might be future utilised for other projects. And in one of the appraisal documents of the project, some information was provided about those other projects, but stated that it was not practicable to carry out a cumulative assessment, as there was very little, if any, information about those, and the advice indicated that it should be considered when those further details became available. The examining authority recommended consent, but said when doing that would permit in bold the effects of the cumulative delivery of the proposed developments with other East Anglia developments are so substantially adverse, the utmost care will be required in consideration of any amendments, additions to those elements of the proposed development. And in granting permission, the Secretary of State declined to take that information into account, and that was the subject of the challenge. But in rejecting that, which was the cumulative assessment ground 2, the Court of Appeal found that a decision maker is entitled to defer consideration of cumulative effects arising from future projects where there was inadequate information available to carry out such an assessment. And interestingly, just harking back to a case from last year, the case of Task together against Sizewell C against Secretary of State for Department for Energy, Net Zero and Climate Change. That was a case which concerned in part cumulative assessment between the new nuclear reactor power station and its water supply, which was agreed to be required to make the power station work. Details of the water supply were not available, even though they were critical at the point consent was granted for the power station, and the Court of Appeal, consistent with this reasoning, found it was possible to defer assessment of cumulative effects until after both became available. And in this case, in EIA, again, the Court of Appeal has found there's no error in doing that. The only slight caveat I would mention about that, although it was rejected in Task, is, of course, if you've granted your consent and started building even the larger initial project, it might be said that the assessment of effects might be skewed when you come to looking at necessary supporting infrastructure that you should have cumulatively assessed at the time, which was the position of Natural England in the Sizewell case. So turning to whether all this might change in the future, well, there is a legislative provision for environment impact assessments and strategic environment assessments to be abolished and replaced with environmental outcome reports. The detail of all of that is left in the Act to subordinate legislation, and so that could be a very significant change. It could be very minor, or it could just be left on the statute book as power and never used. There was a consultation which took place under the previous Sunak administration, which ended in June, about environmental outcome reports. The then government, so the previous Conservative government, saw environmental outcome reports very much as a wholesale replacement for EIA and SEA, albeit that the EoR that they envisaged did follow a similar structure to EIA, so requirements to describe the project, the baseline conditions, the effects of the project at short, medium and long term, and then any mitigation and monitoring. So similar structure to an environmental statement, but interestingly, a proposal to effectively abolish the requirement to do a project-specific assessment if you were bringing forward a project that was within the terms of an assessed planning policy, so an allocation type policy that allocated a housing development, for example. If you were within the terms of that, and that policy had been itself subject to an environmental outcome report, and you were complying with all the mitigation, you wouldn't, it was proposed, need to do another EIA project-specific level assessment. But there's been no response from the current government, which will obviously be the key thing to look out for, and that may be sometime in the future. So SEA cases, so quite a quiet year for SEA. The only case I want to draw to your attention is Greenpeace. This case predates Finch, so the actual conclusions and legal principles that the judge used to dispose of this case, I think, are unlikely to survive Finch, or certainly need to be read with a very significant health warning. But what is important, and I would suggest is useful and postdates Finch, is his conclusion, the judge's conclusion at 103, which is that the factual context in the two regimes, that's EIA, obviously, which Finch was about, and SEA, which this case was about, are sufficiently analogous that important parts of the analysis in Finch are applicable to SEA in the present case. So what this case is helpful in showing us is that the conclusions, in that case, he was applying the Court of Appeals, but it stands to reason that the Supreme Court's conclusions in Finch, there is a basis for reading those across to SEA cases. And then finally, a bit of CJAU, a bit of nostalgia. This is obviously a post-IP completion day judgment of the CJAU, so clearly not binding, but the domestic English courts, English and Welsh courts, can still have regard to that jurisprudence. This concerned a plan or programme, and whether a master plan rather was a plan or programme which required an SEA. This master plan document, which was treated as and acknowledged and brought forward and encouraged development within development plans in Dublin and roundabout, and treated by them as being very important. The question was whether the master plan itself should have been the subject of assessment, even though the development plans made in consequence of it were themselves assessed. And the CJAU said, well, if the provisions of the master plan are purely indicative, then they don't satisfy the second condition set out in the directive, which is that it provides a framework for future development. It's only acts of a mandatory nature which are capable of limiting the discretion enjoyed by the authorities, and thus excluding certain modalities of implementation of projects which might prove to be more favourable to the environment, which is why such acts must be the subject of environmental assessment within the meaning of the directive. So in that case, it was only if the relevant master plan was binding on the relevant competent authorities to grant permission did it require an SEA, and that does have some resonance with our English interpretation of the SEA directive and our subordinate regulations. There was obviously a case in 2019 considering whether the National Planning Policy Framework should have been assessed under the SEA provisions, and the High Court's conclusions was that it shouldn't have been because it didn't set the framework for future development. Obviously highly persuasive, but it wasn't itself a mandatory document. So those are all my observations, and I'll hand over now to Alex Shattock.
Hello, everyone. So my update will be on climate change litigation over the past year. Now, obviously, a bad year for climate change generally, but silver lining, plenty of climate change litigation for the purposes of preparing a case law update. So it's not all bad. And truth be told, it's been a blockbuster year for climate change litigation. Here are the cases we're going to be considering. First case on the list is Boswell in the Court of Appeal. But first, a quiz, not an interactive one. Don't worry, I can feel the sense of alarm reverberating through the screen. No, it's play along at home. Here on the screen are 4 of my favorite things, and you have to guess which of the 4 of my favorite things this case was about. Boswell. Was it about option 1, challenge to a new incinerator? Love an incinerator challenge. They raise interesting questions. Is it an incinerator, or is it a net zero waste to energy plant? It gently warms the waste using the cleansing medium of fire. Always a tricky one, always interesting. Option 2, road DCO challenge, another of my favorite things. I love a road-based DCO challenge. I do quite a few of them. The main reason I like them is the opportunity for road and vehicle-based puns. So many possibilities. EFT must have a great time. I couldn't get any work done personally in those conditions. Option 3, a challenge to a gas-fired power station. Love that. To be honest, I enjoy any challenge to energy infrastructure or just infrastructure, or indeed just anything. I'll challenge anything. If I wasn't a lawyer, I would no doubt be a vexatious litigant in person. This job gives me an important outlet. Option 4, the inevitable heat death of the universe. Love that. When climate change gets me down, I find comfort in the innate transience of all that ever was and all that ever will be. Nothing escapes entropy, so it's not all that bad. And the answer, it was indeed a challenge to a road scheme, bit of a trick question. Dr. Boswell did challenge a new gas-fired power station, DCO, a few months ago. We have a Court of Appeal hearing on that early next year. This one, though, Boswell v. SST, is his Court of Appeal case challenging a number of road schemes. Interesting case, lots of cases were stayed behind it. So the question was, you need to consider cumulative effects, but how regional do you need to go? How localized? What kinds of schemes do you need to bundle together? And the claimant there, Dr. Boswell, said 3 road schemes needed to be considered together. Court of Appeal, though, said no, not necessarily. It's up to the decision maker. As long as you address your mind to cumulative effects, it's rational to compare your schemes to carbon budgets only, national ones, because carbon emissions have no geographic boundary. Similar point to the Bristol Airport challenge on local carbon budgets. So another case here emphasising the Secretary of State's broad discretion in the field of climate change assessment, GHG assessment. Next one, we've already considered a bit. Finch, summer blockbuster, this one, very much the Terminator 2 of climate change decisions. No quiz for this one, sadly, because Ashley has already set out what the decision was about. Just kidding, of course, there's a quiz. Did you really think I'd fill the next 2 minutes of useful legal content? Time for some philosophy. How did the Supreme Court describe the High Court's reasoning on whether the combustion of the oil was an effect of the development? Option 1, stoic. Love stoicism, stop moping around, just do your best and try to be a good person. Love it. Option 2, Kantian metaphysics. I admire the ambition of this one. An analysis of reality independent from human experience. Option 3, Confucianism. I'll be honest, not my personal top 10. Very don't rock the boat. Confucianism, my favorite Confucius quote. It's actually a very common Western misattribution. Hard to find a black cat in a dark room, especially if it isn't there. Great quote. Confucius never said it though. Option 4, Nietzschean morality. Again, not a huge fan, very anti-utilitarian, easily used to justify the domination of the majority by a minority of people. Now, you may be scratching your head thinking, what does any of this have to do with the environmental assessment of the effects on the combustion of oil? I certainly was thinking that when I read the decision, but of course, it's Kantian metaphysics. Here's what the court said. Essentially, there's no point in trying to conceptualize the development of something apart from the things that it inevitably physically causes. If it inevitably causes something, that something is an effect of the development. So Ashley's already covered this in detail. Is it a huge new burden, this case? For fossil fuels, I think certainly not. You just do a bit of additional math, which we were kind of doing anyway. There may be future arguments about what is or is not inevitable, but that will keep us all busy, so can't complain about that. What time is it? It's time for another quiz. Friends of the Earth and Secretary of State for Levelling Up Housing and Communities. What was this case about? Do you remember what Ashley said about it? Well, here are another 4 of my favorite things. This case was about one of them. Maybe that will help. Coal mining, chicken farming, cheese producing, and data center operating, the 4 noble professions of the great British countryside, as Winston Churchill once put it. But one of these professions, noble though it is a creature of the past, and that is, of course, coal mining, which is what this case was about. Beautiful, clean coal. Michael Gove granted permission for a new coal mine in Cumbria. Friends of the Earth and local residents challenged it. Secretary of State and the coal mine company resisted it, at least initially. Permission refused on the papers, renewed, adjourned to a rolled up hearing shortly before the renewal hearing, and then stayed behind Finch. The stay was lifted at the coal mine company's request before the Finch judgment came out. The date was set, but alas, it was too late. Finch came out and the government conceded shortly before the final hearing on the Finch ground. The coal mine company fought on though, so the whole thing was argued about over 3 days. And as we see on this slide, 4 broad issues: Finch, substitution, that is covered, international impact, what net zero means in the context of carbon budget. So I won't go over EIA and substitution, you've already heard about that. But on international impact, FOE, local residents argued the Secretary of State did not adequately address our argument that this was essentially a climate diplomacy disaster that would encourage more coal mines around the world and ruin the UK's reputation. That was the submission. The judge found that these points had to be addressed to the extent the inspector touched on it. The substitution error and the Finch error infected the conclusion on international impacts, because basically the mine wouldn't set a positive benchmark, as was suggested, if it wasn't net zero, because of the substitution argument or the Finch argument. But the judge also found, even if there was no other error, the Secretary of State still had to deal with the argument, had to deal with these offsetting arguments, which was you can't just rely on offsets and encourage others to do so, because offsets are a finite resource. There's only so many new trees you can plant, essentially. There's also a standalone ground from Friends of the Earth about the Section 106 agreement. Basically, the offsets the mine company promised to buy didn't actually count towards the carbon budget as a matter of law. So when the Secretary of State accepted the mine with net zero, it was accepting that it wouldn't have an impact on the carbon budget. The argument really was about whether this mattered, particularly as the mine company had purported to correct the problem with a unilateral undertaking. They also said there's no need for the Secretary of State to address this, and it could have been raised at the inquiry. The judge disagreed, needed to be dealt with by the Secretary of State. It was raised indirectly at the inquiry, and the unilateral undertaking raised further questions that would require findings of fact. So it didn't correct the error, which just goes to show, if you are defending a claim, don't invite the judge to take on the role of the Secretary of State. They don't like it. The point about the realm of the decision maker and the realm of the judiciary works both ways. The second Friends of the Earth case, now this time with other NGOs, Planet Earth, GLP, going after the Secretary of State for energy security and net zero. But first, our final quiz question of this morning: how many successful legal challenges have there been to the UK carbon budget delivery plan? Is the answer A, no one dared to challenge it? Was it B, it was challenged but didn't succeed? C, it was challenged and only once succeeded? Or D, inexplicably, it's been successfully challenged not once but twice? The answer is, of course, it's been challenged successfully on 2 occasions. This was the second. Before we get into it, how did you do on our quiz? 4 questions. I hope you've been keeping track. This is your rank on this slide based on your score. Well, what did the case say, though, Alex? Well, Alex, let me tell you, the Secretary of State has to set a carbon budget. We know that. We love it. Section 13, though, he has to prepare proposals and policies that are actually meeting that budget. Climate Change Act 2008. Section 14, he has to lay it before Parliament. And he keeps getting it wrong. This time, he was irrational, which is not the lowest threshold. The problem was in the briefing to the minister, though, rather than the minister himself, or Secretary of State. So the briefing suggested all the policies would be delivered, which clearly there were risks that they would not. And indeed, if you go into the detail of the document, that was clear. But it was the overall briefing that was misleading in that regard. So that needed to be grappled with, essentially, and it wasn't. There was also no decision that the policies would contribute to sustainable development, only that they were likely to do so, which was not the test. They had to actually do it. So the decision was erroneous in those ways. However, the way the plan was reported to Parliament under Section 14 was okay. So the hard bit, the Secretary of State, the stumbling block is Section 13. So we can expect new carbon budget delivery plan at some point. Third time's the charm. Will we see more net zero policies this time around? Quite possibly. But of course, there's that age-old tension between preserving what we have and building new things. And this government understandably wants to build a lot of new things too. So when those two legitimate aims collide, not yet sure which one will win out in decision making. Next, we have a special international guest case, KlimaSeniorinnen, the Swiss case from European Court of Human Rights. Remember when I told you that climate change had no relevance to the Convention of Rights? Well, I lied. This was the big case alleging Switzerland had breached the human rights of senior citizens by failing to take action against climate change. Failed in the domestic courts and was taken to Strasbourg by 4 individuals and a wider group. 3 allegations: Article 2 breach, Article 6 breach, and Article 8 breach. So life, fair trial, family life. Court held the individuals did not have victim status as the impact of climate change weren't severe enough. But the group did have standing, so it proceeded. And here's the exciting bit. Article 8 encompasses a right for individuals to effective protection by the state authorities from serious adverse effects of climate change on their life, health, well-being, and quality of life. How do you assess this? Well, the test of causation is broad. Could the state's measures have had a real prospect of altering it or not? Which is interesting because in a sort of post-Finch world, we may well be talking about causation more in this context, where the causation question is disputed and needs to be decided. There will be a case about this. Slightly different issues, of course, causation by the development in terms of climate, and causation in relation to human rights breaches by the Secretary of State's inaction, but interesting nonetheless. And then there's this finding that Article 8 requires states to take measures encompassing a right for individuals to effective protection by the state authorities from serious adverse effects of climate change. So a wide margin of appreciation there as well. So family life includes the right to have some degree of protection from climate change. Switzerland breached that right in this case because it basically wasn't even trying. There's no carbon budget, failure to meet its reduction targets, no real plan. So Article 8, they were home. The court didn't examine Article 2 in light of the Article 8 findings. In reality, it would need to be a more serious case, but you can well see what's happening in Spain at the moment, for example, fame arising out of a death caused by climate change. Reasonably likely to see something like that in the next few years. Lastly, the Article 6 challenge also succeeded because the Swiss courts had failed to provide convincing reasons as to why they didn't sufficiently examine the merits of the application. So these kinds of cases do need to be given a full airing. That's that big case in a nutshell. Final case in my presentation is the third Friends of the Earth case in the past year, which leads me to an important question. Are there any government departments that haven't yet been judicially reviewed by Friends of the Earth? For a researcher that I am, I had a little look. There are indeed a few departments that haven't been judicially reviewed by FOE, but truth be told, there aren't many. They sued the Ministry of Justice, for example, in 2017 over the Aarhus cost cap. Also judicially reviewed the Poor Export Credits Guarantee Department in 2022. Export Credits Guarantee Department, possibly the most obscure ministerial department in Whitehall, and they were probably delighted just to be noticed. Why do you need an entire government department to guarantee export credits? I'm not sure, particularly when the former Department for International Development, responsible for our entire overseas aid budget, now has the hot desk in the Foreign Office. Civil servants managing our overseas aid budget, I would say they're in the wrong game. You don't want to fight with Sharon over her special ergonomic chair. You should be guaranteeing export credit, my son, a whole department. They must live like kings. But I digress. what departments have not been judicially reviewed by FOE? Well, let's just say Department for Work and Pensions must be high on the list for next year. The Department of Prices and Consumer Protection has never been judicially reviewed by Friends of the Earth because it only existed between 1974 and 1979. The problem with Wikipedia is you go down such a rabbit hole that you forget why you were originally there, what you were looking at, which in my case is a case law update related to the third FOE case on the list about the National Adaptation Programme. This is a programme published pursuant to the duty in the Climate Change Act 2008, another 2008 Act claim. Section 58, what is your programme for adapting to climate change, government? Buy a lot of raincoats, job done. Well, it wasn't that bad, but the Climate Change Committee weren't too pleased with it. FOE and 2 affected individuals for challenge, arguing the plan did not comply with the duty, drawing on the Swift case. Failed to consider risk delivery. That was the other allegation. Shades of the Climate Budget Delivery Plan case. PSDD challenge 2 and breach of HRA Section 6, again drawing on the Swiss case. However, the challenge did not succeed. Basically, the court found you should approach legislation on its ordinary meaning. It's only if it's incompatible with human rights that you might need to bend the interpretation a bit. That's clearly relevant to any legal dispute. These kinds of bringing in these kinds of arguments, including, for example, human rights argument relating to TCPA 1990-2008 Planning Act, any legislation, really. You give it its ordinary meaning. If it's incompatible with the rights, then you may have to interpret it slightly differently. Here, the statutory provision in question was pretty broad. Unlike the Part 1 obligations in the Climate Change Act, under consideration in the Carbon Budget Delivery Plan case, the risks here, Section 58, just needed to be addressed. So it then becomes an irrationality challenge. Judge found this is compatible with the Swift case because there's a wide margin of appreciation. And basically here we're arguing about adequacy of measures rather than whether any measures needed to be taken, as in the Swift case. I should also add the PSDD argument failed essentially because there was a follow-up exercise done which was adequate. Does this mean that the Swift case won't really come up in the UK? Again, I don't think so. There will be further cases, but I think it's fair to say it'll always be an uphill battle because the UK is ahead of several other European countries on emissions reduction, on our statutory framework, and of course our legal system has the Wednesbury standard that applies to decision makers. What I think will happen is that officials who are concerned with primarily environmental matters will in future need to be more mindful of human rights impacts in a way they wouldn't have done previously. You'll need to show you've considered, for example, the Article 8 implications of not doing enough on climate change, because there will be more challenges in the pipeline. I'll now hand over to Alex.
Hello, everyone. I'm going to be talking about 2 cases on energy efficiency standards, which were both heard and decided by the Administrative Court this year. They're both called Rights Community Action against Secretary of State for Levelling Up Housing in Communities. One was in February and one was in July. The first was in favour of the claimant and the second in favour of the defendant. But the second one's on appeal to the Court of Appeal and is ongoing. They both concern a common underlying issue, which is the extent to which local planning authorities can adopt development plan policies which require new developments to meet energy efficiency standards that exceed the building regulations minima. Just to give you quick background, you've got Section 1 of the Climate Change Act, and that sets the 100% reduction in emissions by 2050 target, and that has replaced the previous 80% target. Since then, we had a parliamentary declaration of climate emergency, and lots of local authorities, several hundred of them, also declared a climate emergency in the wake of that. And then the question arose for those local authorities: how do we actually give effect to trying to do something about the climate emergency? And a lot of them have turned to their development plan policies, because that's something where they have quite a lot of power and control, and thought, well, the construction industry has a considerable impact on the climate. What can we do to address climate change through our development plan policies? And a lot of them have looked to introduce energy efficiency standards, which in some cases require net zero emissions of greenhouse gases from new developments, or require that in relation to some specific developments. And the Salt Cross case is one that emerged from the local plan of West Oxfordshire District Council. West Oxfordshire District Council have a local plan, and in the local plan there are policies which seek to allocate the Salt Cross Garden Village area as an area for a new town, in essence, a garden village, which will be a net zero development. And they then promoted an area action plan. And you see on the slide that policy GV3 of the examination submission plan provided that the objective of this plan was to design buildings fit for the future, mitigating the impact of Salt Cross on climate change by achieving zero carbon development through ultra-low energy fabric and 100% use of low and zero carbon energy with no reliance on fossil fuels. So an exemplar development that would reach the net zero threshold 20 years before everybody has to do it in 2050. So build it out now, start developing the technologies, and make sure there's no need for retrofitting by 2050. That then went to examination, and the inspectors concluded the plan was unsound, and it followed from that it was unjustified as well. Their reasoning was because they considered the plan was inconsistent with a written ministerial statement from 2015. Now, a written ministerial statement is a mechanism by which central government delivers statements of policy. And those statements of policy sit alongside the more comprehensive and formal statements that we have in the National Planning Policy Framework and in the guidance. So that written ministerial statement sought to address in 2015. So it was just in the outgoing days of the coalition government in 2015 before the election. And it said, for the specific issue of energy performance, local planning authorities will continue to be able to set and apply policies in their local plans which require compliance with energy performance standards that exceed the energy requirements of building regulations until commencement of amendments to the Planning and Energy Act 2008 in the Deregulation Bill 2015. This is expected to happen alongside the introduction of zero carbon homes policy in late 2016. The government has stated that from then, the energy performance requirements in building regulations will be set at a level equivalent to the outgoing Code for Sustainable Homes Level 4. Until the amendment is commenced, we would expect local planning authorities to take this statement of the government's intention into account in applying existing policies and not set conditions with requirements above a Code Level 4 equivalent. Now, one of the difficulties was that none of this happened because after the election, the priorities changed. The aspects of the Deregulation Act of 2015 that became an act but weren't brought into effect. The amendments to the Planning and Energy Act weren't brought into effect. And the Code for Sustainable Homes Level 4 was also took a swerve and was adopted differently. So none of these expected measures came in. But the written ministerial statement, indeed, to this day, in many other respects, is still extant policy, and it continued to set out these provisions. The examining inspectors said that they considered the area action plan in requiring net zero carbon development was not consistent with the written ministerial statement. So the Rights Community Action, in response to this finding, decided to, well, there was a preliminary finding along those lines. And the Rights Community Action got involved at that stage. But when the inspector's recommendation was published, at that point, the next stage was for the local authority to adopt the plan subject to main modifications. And in effect, the local authority has no discretion not to accept they're called recommendations, but there's no option not to accept them. The only option is not to adopt the plan at all. Rights Community Action then brought a judicial review at this stage of the recommendations by the Planning Inspectorate. And that's quite an unusual course, because most challenges, statutory challenges, are brought under Section 113 after the adoption of a plan. And so there were two preliminary objections raised, both by Grosvenor, who's the landowner and developer, and by the Secretary of State to this claim for judicial review. The first was standing. They said Rights Community Action doesn't have standing. They said West Oxfordshire District Council could bring a claim, but not an NGO that had only a fleeting involvement in the process of making the plan. And the second was to the question of prematurity and ouster, and whether a judicial review could be brought before the adoption of a development plan document. On standing, the judge, Mrs. Justice Leven, disagreed with the other parties and held at paragraph 61 of her judgment that she did not read the decision in the Good Law Project case as seeking to create a new test for standing of whether there is a better placed claimant. So in that case, there was the Runnymede Trust, and they had not brought a claim for judicial review, and the Divisional Court in the Good Law Project case appeared to have ruled out the Good Law Project bringing a claim on the basis there was a better placed claimant. But Mrs. Justice Leven said such a test would be a radical tightening of the rules in standing, this being a long step from a requirement that a claimant is not a busybody. There may be many judicial reviews where it could be said that someone other than the claimant was better placed, in the sense that they were more directly affected by the decision. But there may equally be many reasons why such a person chooses not to bring such a challenge. So Mrs. Justice Leven addressed that Divisional Court decision on standing, which seemed for a period to have narrowed the standing tests. She, however, indicated and held that it wasn't establishing a new test. There's been another case which has looked at that question of standing and the Good Law Project's apparent reliance on better placed claimant by Mr. Justice Swift himself, who was in fact in the Good Law Project Divisional Court, and that's called Batman Gage against the Charity Commission. The other objection was to the question of whether a JR could be brought before the adoption of the plan, i.e. a challenge to the recommendations by the inspectorate. There'd been 3 prior cases concerning that issue, and I've listed them there: Marydown, IM Properties and CK Properties. In the Marydown case, Miss Justice Lindblom held that the court could entertain a claim for judicial review in the run-up to a statutory process. So he indicated that the kind of claim that was being brought was feasible, obiter. In IM Properties, however, Mrs. Justice Patterson had taken the view that a document becomes a development plan document once submitted for examination, and therefore fell within the preclusive provisions of Section 113, which says that a claim can only be brought within the 6 weeks after the adoption of the plan by the local authority. So that case went the other way. But there was another case called CK Properties, in which Mr. Justice Supperston had held that the decision to publish a draft plan in accordance with Regulation 19 and thereafter submission to the Secretary of State for examination under Section 20 was amenable to judicial review. Mr. Justice Supperston said that only a challenge to an adopted plan is precluded by Section 113. His reasoning was based in part on the fact that Section 17 of the Planning and Compulsory Purchase Act 2004 states that a document is a local development document only insofar as it is adopted by resolution of the local planning authority. So that preliminary objection was navigated by the claimants as well, and the judge moved on to consider the grounds. And there was an objection then raised that the ground about the question of the meaning of the written ministerial statement was really about its application, and its application was a matter of judgment for the Secretary of State. Mrs. Justice Leven rejected that, said it was a question of interpretation, and she therefore turned to the question of the consistency of the written ministerial statement with the area action plan, and held that the inspectors had been in error in their interpretation of the Secretary of State's written ministerial statement. She held the WMS has to be interpreted in accordance with the mischief it was seeking to address and with an updating construction. The WMS is not a statute but a policy, but even with a statute, the mischief is a highly relevant consideration in interpretation, and the principle of applying an updating construction is well established. In order to make sense of the WMS in the circumstances that applied in 2023, it is essential to have regard to the fact that the restriction on setting conditions above Code Level 4, upon which the inspectors relied in the report, no longer apply. To interpret the WMS so as to prevent or restrict the ability of the local planning authority to set a standard higher than level 4 is plainly wrong in light of subsequent events. For this reason, the inspectors erred in law in their approach by finding that Policy 2 of the AAP was inconsistent with the WMS. So Mrs. Justice Leven allowed allowed the claim on that ground. There was a defence raised that it would make no difference. Defendants always try and raise that defence under Section 31(3)(c) of the Senior Courts Act, but she rejected that defence. And accordingly, the inspectors have been sent back to reconsider their report. It's quite a complicated situation because there's been quite a few local authorities which had already sent plans for examination, which had been found sound, and which set energy efficiency standards above building regulation levels, i.e. requiring net zero type developments. So Cornwall Council, Bath and North East Somerset Council, and Central Lincolnshire have all got plans that require developments to establish energy efficiency standards well beyond those levels. So there's been an inconsistent practice by the Secretary of State across different plans. So Rights Community Action having succeeded, the Secretary of State responded by issuing a new written ministerial statement to overwrite aspects of the 2015 Eric Pickles statement, which had been interpreted by Mrs. Justice Leven. And the new ministerial statement now says, it's on the slide, the improvement in standards already in force alongside the ones which are due in 2025, that's the future home standard that's supposed to be coming in, if it ever does, next year, they demonstrate the government's commitment to ensuring new properties have a much lower impact on the environment in the future. In this context, the government does not expect plan makers to set local energy efficiency standards for buildings that go beyond current or planned building regulations. The proliferation of multiple local standards by local authority area can add further costs to building new homes by adding complexity and undermining economies of scale. Any planning policies that propose local energy efficiency standards for buildings that go beyond current or planned buildings regulation should be rejected at examination if they do not have a well-reasoned and robustly costed rationale that ensures, and then they set out various conditions and flexibilities, which I haven't set out, but it's in the WMS. So the response of Rights Community Action was to bring the second claim, and at the top of that slide there you see the citation 2024 EWHC 1693, decided in July, decided against the claimant in this case, but is now on appeal to the Court of Appeal. Two significant grounds were brought. The first was a failure to comply with Section 19 of the Environment Act 2021, which had just come into force. The claimant alleged in November 2023 this came into force. Section 19 provides that a Minister of the Crown must, when making policy, have due regard to the policy statement on environmental principles currently in effect. The Environmental Policy Principles Statement, Environmental Principles Policy Statement provides policy making. The legal duty to have due regard to this policy statement applies to ministers when making policy. Policy can be broadly understood as an intended course of action adopted to achieve an objective. And it then seeks to embed 5 principles of environmental law. the most relevant here were the integration principle and the prevention principle. It also mentions other principles like the precautionary principle. So what the Section 19 duty has sought to do is to bring a lot of principles from international environmental law to bear on decisions by ministers when making policy. So it's sort of bringing home a number of principles that we find permeating the Habitats Directive, the EIA Directive, all of those instruments that we've been hearing about in the course of this morning, and to compel the Secretary of State to consider those. The first ground was that the Secretary of State failed to consider those Section 19 EPPS, and the defendant accepted that there had been a failure to take into account the EPPS. However, what the defendant then did was a retrospective assessment, and J held that the failure to comply with that duty was not an error of law, which required the decision to adopt the policy to be revisited. And she held that a summary form assessment undertaken after the event was a legitimate form of discharge of the Section 19 duty. And she accepted submissions for the Secretary of State that the duty is a diffuse one requiring proportionality whose objectives are not clear. And so that there was a much more complex exercise required. So that point is on appeal. The interesting point is that the Office of Environmental Protection and the Green Alliance have applied to intervene in that appeal. The second point was the ground 2 was what was described as emasculation of statutory powers. It was held that the argument was that the WMS unlawfully restrains local authorities from exercising their powers to set energy standards in exceedance of those set out in the building regulations. The written ministerial statement says that the government does not expect plan makers to set energy local efficiency standards for buildings that go beyond current or planned building regulations. And the argument by the claimant was that local authorities have power under Section 1 of the Planning and Energy Act 2008, apparently to set energy efficiency standards that go beyond building regulations. And so the government was seeking to cut down or emasculate a power conferred on local authorities by Parliament through executive diktat. And it was saying that was an unlawful exercise of executive power. And there's a couple of Supreme Court cases which related to that. However, Mrs. Justice Leven rejected that argument based on her interpretation of Section 1. She held that its purpose was itself to prevent inconsistency of standards, and that was what the new written ministerial statement of 2023 was trying to achieve. And then she held that some of the flexibility within the written ministerial statement meant that the policy was not emasculating the power. So that point has also gone on appeal to the Court of Appeal and is awaiting permission on that point. I've set out Section 1 there so you can see what the powers say. It says a local planning authority in England may, in their development plan documents, include policies imposing reasonable requirements for, and then C, developments in their area to comply with energy efficiency standards that exceed the energy requirements of building regulations. So the question is whether that means what it says or something slightly more subtle, which the judge found in reliance on subparagraph 5 in holding that policies included in development plan documents by virtue of subsection 1 must not be inconsistent with relevant national policies for England. So the argument was it's subject to the written ministerial statement, which is a relevant national policy for England. So this is the summary and conclusion. As I say, that case is before the Court of Appeal, but at the moment we have the decision of Mrs. Justice Leven from July. And so authorities like West Oxfordshire District Council are in a bit of a bind because having promoted their plan, there's a new WMS. As often when new policy comes in, it disrupts the local plan policies that are in the course of being made. Clearly, the new WMS will need to be taken into account by local planning authorities. It will need to be taken into account by inspectors at examination. It does contain some flexibility within it to allow for energy efficiency standards that exceed building regulations, but it's pretty limited and difficult to see how that could be achieved in accordance with the WMS. So in effect, it currently stands as largely a restraint. Perhaps there's a way around it, but the easier course is going to be simply to wait for the future home standard. That is not a net zero standard, but it's certainly a much higher level of energy efficiency required of it. So it seems that for the near future, there is a significant obstacle to local authorities trying to promote garden villages, net zero type developments through this current WMS. Of course, it was a policy statement by the previous government. Whether the new administration has had a time to think about it and whether it still supports the previous government's statement is unclear. But of course, they are seeking very high build-out housing numbers. And so it may well be that energy efficiency is not so much a priority as delivery of housing. So that's where those two cases stand. Keep an eye out. No doubt there'll be some way of finding out if permission is granted and if this case goes ahead. Thanks very much. I'll pass to Matthew for the next talk.
Thanks very much, Alex. So I'll be providing the final talk for the webinar. I've noticed that we are down about 70 participants from the start, and I think most of those participants left during Alex Shattock's talk. So I don't know what that says about the quality of his quiz. I'm going to try and bring the participant list right back up to where we started by talking about the issue of embodied carbon. Now, embodied carbon isn't a Halloween outfit, i.e. a skeleton. It's something which is actually quite difficult to find a good definition of it. And I think the best one that I could find is in the London Plan 2021. And it's basically the important distinction is between operational carbon emissions, so the carbon emissions that arise from actually operating a development, and conversely embodied carbon emissions, which are those associated with the raw material extraction, manufacture, transport of building materials, construction of the development, the emissions associated with the maintenance, repair and replacement of the development, and the dismantling, demolition of the development, including the eventual disposal of materials. So it's the whole life of a development as opposed to just the operation. And that's why we also have this concept of whole life cycle carbon emissions. They are the total greenhouse gas emissions that arise from a development over its lifetime. And it's really relatively new that we assess whole life carbon emissions as opposed to just the operational impacts. The world is still, I would suggest, catching up on the importance of assessing these emissions as part of assessing whether to grant planning permission for any development. And of course, it's all necessitated by the climate emergency that we find ourselves in. The House of Commons Environmental Audit Committee published a report in May 2022 called Building to Net Zero, Costing Carbon in Construction, which makes the important point that 25% of the UK's total greenhouse gas emissions are attributable to the built environment. So if we are to meet net zero, we are going to need to be fundamentally reforming the way we do things in the built environment. And embodied emissions from the demolition and construction of buildings amount to some 40 to 50 million tonnes of CO2 annually, more than emissions from aviation and shipping combined. Finding the appropriate balance, according to the report, between demolition and new building versus reuse and retrofitting of existing buildings is crucial to a built environment policy which delivers sustainable outcomes. And I think the point I would make is that, of course, there are lots of development priorities at play in the current government's agenda. For example, building significantly more houses, which does raise the question of, if you have to use an awful lot of carbon and generate a lot of carbon emissions to build new buildings, should you not be doing as much as you possibly can to conserve what buildings you already have? Is the most sustainable building the one that already exists, in other words? So the EAC were very scathing in the way that the current government, or previous government now, were approaching this matter. They said, they issued the warning that if the UK continues to drag its feet on embodied carbon, it will not meet net zero or its carbon budgets. So that's quite a stark warning. Very significant waste generation at the moment, clear policy imperative to reduce the consumption of resources in the building and construction sector. There is some legislation and policy that touches on this stuff, but I'm of the view that things do need to go quite significantly further if we're going to get anywhere on this. There is the general legal requirement for all development plan documents to include policies designed to secure that development and the use of land contribute to the mitigation of and adaptation to climate change, which is a general duty which would apply in this context. We then have the currently worded framework, paragraph 157, which says the planning system should support the transition to a low carbon future. It should help to shape places in ways that contribute to radical reductions in greenhouse gas emissions and encourage the reuse of existing resources, including the conversion of existing buildings. So a duty to encourage, a requirement to encourage the use of existing resources. So the question is, does the policy requirement need to go further than merely encouraging? And I'll touch upon this paragraph later when I discuss the M&S legal challenge. The London Plan then does have some policies which deal with whole life carbon, policy SI2, policy SI7B, but these only apply to referable applications, i.e. applications which are required to be referred to the Mayor of London to be determined, not all applications. There is then London Plan guidance for applying those policies, but again, that's guidance only, not policy, and it only applies to London in any event. The M&S case, this is a short chronology. They made the application in June 2021. In November of that year, the council resolved to grant planning permission. They shortly after were told that the Mayor of London would not be opposing the grant of planning permission. The Secretary of State then called the application in for his own determination. That was Michael Gove as Secretary of State in the previous government. There was then a 2-week public inquiry in October 2022. And then on the 20th of July 2023, the Secretary of State, who was Michael Gove, again, there had been some Secretary of States between the call-in decision and the decision to refuse planning permission. But yes, there was the refusal of planning permission in July 2023. There was then a legal challenge against that refusal of permission, which was heard by the High Court and quashed, which resulted in a quashing of the planning permission, the refusal of the planning permission in March 2024. This is the existing building, or the existing buildings. You can see that there are 3 of them. The middle one is of the greatest heritage significance. That's how things look at present. The proposed scheme is this. And of course, there are all sorts of issues about this development, whether it's a good thing from a range of different perspectives, including design and heritage impacts. But obviously the focus of this talk will be on the issue of embodied carbon. The cost of the scheme in terms of embodied carbon was agreed to be in the region of 40,000 metric tons of CO2. That was just for the construction of the new building. And that's the equivalent of driving a typical car 99 million miles, i.e. further than the distance to the sun. Added to this is the further CO2 cost arising from the demolition of the existing buildings. And as the inspector noted, and again, it was hardly controversial, the amount of embodied energy, that is the energy that would go into the construction, would be substantial. The Secretary of State, in their decision, agreed with the inspector that a substantial amount of embodied carbon would go into construction and that this would impede the UK's transition to a zero carbon economy. But only in the final analysis gave the embodied carbon issue moderate weight in the planning balance. The Secretary of State interpreted paragraph 152 of the framework, as it then was now 157, as reflecting a strong presumption in favour of repurposing and reusing existing buildings. That wording got himself into a spot of bother in the High Court. The Secretary of State disagreed with the inspector's conclusion that there is no viable and deliverable alternative to demolition in a new building, and did not consider it was possible to reach a conclusion on this issue in light of the available evidence. But the primary driver in the Secretary of State's decision to refuse permission was the heritage impacts. The development, so the Secretary of State found, conflicted with the development plan by reason of breaching heritage policies, and material considerations didn't justify a departure from the plan. The High Court, as I say, quashed the refusal of planning permission. The court found that the Secretary of State had misinterpreted 152 of the framework as creating a strong presumption in favour of retaining existing buildings. That language is not used in 152, which is merely an encouraging policy. The Secretary of State was also found to have failed to give legally adequate reasonings for disagreeing with the inspector's conclusions on a number of things. Firstly, the absence of any viable and deliverable refurbishment options for the buildings, and secondly, the impacts of refusing planning permission. The court also found that the Secretary of State had misinterpreted London Plan Policy SI2C, which is the offsetting requirement, as applying to embodied carbon as opposed to operational carbon. The court did, however, find that the Secretary of State's heritage appraisal of the scheme was lawfully reasoned, notwithstanding that being one of the grounds of challenge. So we are now in the process of a redetermination. There have been multiple exchanges of further representations, including in relation to embodied carbon issues, that have taken place since April 2024, most recently just a couple of weeks ago in October. The most recent indication, although I don't know whether this is affected by the receipt of further information, but there was an indication from the current Secretary of State on the 5th of September that there would be an M&S decision on the 5th of December 2024. Save Britain's Heritage, who were my clients at the High Court challenge and the preceding inquiry, continue to argue that M&S have failed to comply with London Plan guidance on the circular economy and on whole life carbon assessments by failing to sufficiently demonstrate the absence of a viable and deliverable comprehensive refurbishment of the buildings, thereby avoiding the heritage impact and the embodied carbon cost of demolition and the construction of a new building. By contrast, M&S contend that they have done enough to show that there is no meaningful alternative to their proposal for the site. It remains to be seen what the new Secretary of State's decision will be, i.e. primarily whether to grant or refuse planning permission. And within that, and I think importantly, how significant will the issue of embodied carbon be to that decision? Will it be something which, as per the previous Secretary of State, is a matter attracting moderate weight, where the bigger issue in the case is the heritage impacts, or will it be an issue which is elevated towards some kind of more significant status by the new Secretary of State? We will see, hopefully by the end of this year, if not early next year. More widely, there are a few points I just want to raise finally before we finish. What will the new government do to strengthen law and/or policy on embodied carbon and retrofit? There is still, in my view, quite shamefully, no national policy requiring the assessment or control of embodied carbon emissions from buildings, despite the built environment accounting for a quarter of the UK's total greenhouse gas emissions, and the UK's commitment to achieving 68% reduction in emissions by 2030. There was nothing in the recent consultation on the proposed changes to the NPPF on this issue, although interestingly MHCLG did separately run a survey ending last month, to quote, on whether national planning policy and guidance needs updating in relation to the demolition and redevelopment or retrofit of buildings. And I hope some of the people listening to this talk participated in that survey. There is then also the question at the local plan level: how will local plan policies on retrofit develop over time? I think an interesting case example for this would be Westminster City Council's own city plan partial review, retrofit with a new retrofit first policy. They had their Reg 19 consultation from March to May 2024, but no doubt there are others as well who will be putting forward policies like this in their plans. And then finally, can other regimes be amended to encourage the reuse of existing buildings? For example, VAT rules. There are certain exemptions from VAT for new buildings which don't apply for refurbishment. Can more be done in the building regulations context on this issue? Do we need to look again at permitted development rights? Is it too easy to knock down existing buildings using PD rights, or either to just demolish or to replace with a new building? So these are all the sorts of questions which are orbiting around the primary issue of whether there will be something new in law or policy from this government on the very important issue of embodied carbon. So that's all I wanted to say for present purposes, but do ask any questions in the wider panel discussion, which I think is now following the conclusion of my talk. Thank you very much indeed for listening.
Thanks very much, Matthew, and thank you, everyone. An awful lot to digest there. And in answer to one of the questions, there will be very shortly a link sent to you all of the recording and of all the slides. So I hope that helps in being able to keep up with everything that's been said. Matthew, I think you're taking centre stage on the screen. I'm not quite sure why, but it's happy to see you there. We have a few questions. We have some time for them. So I'm just going to ask one first, which came in the chat box. And this is probably for Alex Shattock. The Friends of the Earth Challenge on the 6th carbon budget. What do you think this and other things indicates about local plans needing to basically incorporate some sort of carbon budget and assessment of whether the spatial strategy is able to achieve net zero? We don't see much of that in local plans at the moment. How much do you think that would be a advisable route?
Well, it could well be a good idea. I wouldn't say a regional or local plan specific carbon budget is a hard legal requirement. But you should bear in mind your statutory obligation, which Matthew referred to. Section 19 of the Planning Policy Purchase Act 2004, development plan documents must, taken as a whole, include policies designed to secure that the development and use of land in the LPA's area contribute to the mitigation of an adaptation to climate change. So having some kind of carbon budget would be one way of doing it, but no doubt there are other ways to do it as well.
Thanks, Alex. And I think the difficulty with that sort of broad requirement is similarly with the one, I can't remember the section number, but the one that requires to contribute towards sustainable development. They are quite difficult provisions to hang any kind of challenge on. So whilst they could be a desirable way forward, I think it's quite hard to enforce anything like that as part of a local plan drafting or examination consideration. And as we know, I think from the road challenges, one of the issues is there isn't a local carbon budget. So it's very difficult to require any assessment by local targets, isn't it?
Absolutely.
Yeah.
I think the point is the carbon budget relates to the Section 1 of the Climate Change Act duty, which is on the Secretary of State. So it doesn't trickle down to the local level.
Yeah, and it's a national budget because of that as well. So it's very hard to assess against anything more local than that. Another question, going back to Nick's talk. Nick, just going right back to your first case that you discussed, the Bradbury case, where there was a finding of unlawfulness in relation to the appropriate assessment and the background papers. And you explained there that whilst both grounds were upheld because they were interlinked, but the court decided not to quash, even though, could be said probably that it was a rubber stamping exercise and there hadn't been consideration and there hadn't been the background papers put in the public domain. What sort of circumstance do you think would have led the court to quash in that sort of for that sort of error?
I would imagine quashing is probably the more normal outcome. The facts of this case were pretty exceptional. It had a lengthy history. As I said, there were 2 previous quashed planning permissions already. There were 4 relatively well-known issues in dispute relating to, for example, whether this was a cover for the stock levels of the sheep to increase, whether particular hard standing was going to magnify or resolve pollution, a report about how the farm was managing itself generally, and then a suggestion that the HABS regs the HABS regulation assessment needed to be broader. And effectively the court was like, everyone knew what was going on. Everyone knew what the arguments were. It's really hard to see anything else that would have come out of the woodwork. The committee, obviously, it was a unanimous unwhipped decision, and it was an unwhipped decision, still came to unanimous outcome to grant permission. Nobody suggested there were anything that should more have been taken into account and has been missed. So I think it was particularly fact specific in that case. I would imagine more commonly you would see a quashing rather than it just continuing.
Yeah. Like in those other cases where there's been background paper challenges, particularly meaning that people are excluded from commenting effectively on that information. But as you say, if it's been rigorously assessed and commented on repeatedly, it's difficult to see how it would have made a difference. Yeah,
exactly. The judge made one of the points that the arguments had already been volubly made and rejected. So lots of public engagement and lots of rejection of those points made already.
Yeah, fine. Okay. Ashley Finch, this was a real big case, made lots of waves. How much, though, given the concession in that case, and probably the likely concession in any other case relating to extraction of fuel for combustion, that the fuel will be used for combustion. But given that concession, how much do you think the general tenor of the sort of principles from Finch will be in practice limited to those sort of extraction of combustion fuel cases, as opposed to more general cases where the issue of the likelihood of downstream effects is more nuanced?
Well, I think they would be. In practice, the implication is quite limited. I think even if a court would be encouraged by the Supreme Court's analysis about causation, did decide to get a little bit deeper into whether something was a causative effect of a particular project, I think it's still extremely unlikely that, absent a concession, a court would get into whether you could evaluate that against some kind of meaningful methodology, because that is sort of pure planning judgment territory and really turning on highly specific technical details. So, say for one point though, which is that in one of those Badger Cull cases, Mr. Justice Holgate, as he was in that case, said that the quid pro quo of the deference for technical scientific judgments and the sort of super hands-off the court approach the court takes to that is that the decision maker supplies adequate reasoning to see that they've had the principles well in mind. So it might be that a decision maker would fail to turn their mind to the adequacy of an assessment, as in whether it's possible to adequately assess the effects, or it might be that they've failed to decide whether it should be spelt out in an environmental statement. But beyond that, I think a court would say that's an evaluative judgment for them in much the similar way to the Court of Appeal did, and that's provided they supply adequate reasons why they've not assessed it or required it to be assessed, or then that's fine.
Yeah, exactly. Once they give reasons, the test of irrationality, which is what it would come down to when it's evaluative judgment, would be as high as it is in any other case, probably, wouldn't it?
Absolutely, maybe more so because of the technical detail that would be involved.
Yeah, and the deference to that sort of type of technical judgment. Yeah, sure. Okay. Just on retrofit, Matthew, do you think it's difficult, isn't it, because of the the balance between viability and the just general position of developers in terms of greenfield sites or anything. It's easier in a lot of cases. It seems to be easier to just knock down and rebuild, because otherwise it wouldn't be happening so much. With how you get that balance in policy, have you got any thoughts on how you judge how you weigh the two things, or is your point that you need to at least have that policy more in stronger terms in retrofit, so that it can then be balanced? Is that where you're coming from in relation to your sort of more wider policy considerations?
I mean, I definitely think that the policy and potentially the legal framework need to go quite a lot further than they are now, given the climate context we're in. I just don't think there's a sufficient degree of seriousness that's being applied at the moment to the retention of existing buildings. I mean, I'm not calling for an absolute blanket ban on knocking down buildings. I don't think anyone who is interested in this issue would seriously be suggesting that. But it does need to be more difficult than it presently is. For example, the fact that there are PD rights to demolish buildings outside of conservation areas strikes me as quite a surprising position in the current in this day and age. So I think that there does need to be quite a significant beefing up of the policy framework to make it more difficult, not impossible, but certainly more difficult. Which needs to be accompanied by changes to the tax rules, as I suggested as well. I mean, at the moment, it's just frankly not good enough for the framework to be saying encourage the reuse of existing buildings, because that's quite easy for developers to say that they've done or complied with. And I think, frankly, the way that Westminster City Council are currently going about things with their retrofit first policy is much more what I'd like to see applying across the land. Yeah,
exactly. I mean, if you have that policy hook, then it can at least be properly taken into account. And I think I was quite struck by the degree of carbon you're talking about there. It's not simply a side issue. It's quite, it seems to have been a bit of a blind spot in terms of the climate change ambitions and duties.
I mean, it's greater than the aviation sector and the shipping sector combined.
Wow.
The greenhouse gas emissions from the built environment and construction sector. So it's a pretty significant issue if we're going to be meeting net zero. We need to get it right, and I don't think we are at the moment.
Okay, something to think about. Thank you. Just one last question that's come up on the chat. Water neutrality. This is a question for you, Nick. It's actually something that's come up quite recently in the inquiry I've done as well. The legal position for applying for Grampian conditions in Section 106 to secure a mitigation scheme at a later stage to satisfy the habitat regulations and enable permission to be granted. Does that achieve a reasonable level of certainty through an appropriate assessment? I think there's been some decisions in Horsham, some planning inspectorate decisions in Horsham, particularly about this, where I think that you can tell us, but I think the planning inspector certainly has allowed permission, hasn't, on that basis of a Grampian and Section 106 position obligation, requiring that water neutrality scheme to come forward later, pre-commencement.
Yeah, so there's two distinct legal tests that you've got to jump over, and I think there can be a tendency to muddle them up a little bit. So the first is the legal test for passing the HABS regs assessment, and that's obviously the Reg 63.5. You've got to be confident there's no adverse effect on site integrity. There is CJEU case law. I can't remember the case off the top of my head, but definitely CJEU case law and Advocate General opinion saying you can take into account the strictness of conditions and base your finding on the idea that a condition is strict enough that there won't be an adverse effect. So you don't have to be jumping through that hoop now if the condition is strict enough that there won't be an adverse effect. Then you've got the test for imposing a Grampian, which is effectively you can use a Grampian unless it's really high test. There's no I can't remember the technical term, but no possible way.
Exactly. No risk at all. No likelihood at all of you being able to comply with it, I think. which is a
Exactly.
pretty low threshold, really.
It's a very low
Yeah.
threshold. So to get over the Habs regs thing generally, I think you probably could impose a Grampian and then rely on that Grampian as a reason to pass the threshold. You then get into a second, though, planning judgment question, which is whether that's good planning, because you can end up with a pure proliferation of consented developments in an area, which, you know, if, for example, one of the big nutrient or water schemes suddenly comes forward, someone figures out how to unlock it, you've then possibly got too much, or you don't have control over which one actually comes forward. So you've got that sort of second planning judgment of, do we want to be consenting all of these schemes subject to a Grampian, or actually do we want to wait and see its result and then see what happens? So doable, legally doable, definitely, but I'm not sure how that planning judgment is going to end up being answered. I think we'll probably need to see some guidance from I think there has been a Secretary of State decision.
There has, yeah, and that was a preoccupation. That was actually, I think the Secretary of State allowed a preoccupation condition, so actually allowed for the potential for a number of homes to come forward, even actually be built prior to the water neutrality scheme being in place. So yeah, as you say, it's a balance with the delivery, but the problem is, if when you've got this water neutrality potential barrier, if you hold everything back until it's completely sorted and the, you know, T's are crossed and the I's are dotted in terms of a mitigation scheme, you could then have a big delay with anything coming forward. So yeah, it's a difficult balance, as with everything else. Anyway, I think we've just gone over our time a little bit. Thanks everyone for staying the distance, and do let us have any comments. And also you should get, as I said before, you should get the recording and the slides very shortly. And do tune in. I think it's next week. Is it next Monday for session 2 of the High Court Challenges series? So thanks very much all, and have a good week.
Bye.
Bye.
Thanks everyone.